What I have for you today is a case about international tax, and yet it is not about international tax at all. We're talking about the Danish cum-ex case against a number of defendants before the UK courts. And you can see here we're looking at the decision from the Court of Appeals. It is very fresh from the 25th of February, and it is between Skatteforvaltningen with the Danish tax authorities and Solo Capital Partners, and we'll talk a bit about them in a moment. So to talk about what the cum-ex case is, it basically involves that you have a shareholder, as you can see here, which owns shares. You've got another party selling those shares short. Then there's a dividend paid and dividend withholding tax withheld in step 3. Obviously when the dividend is paid, the company reduces in value because there is a dividend paid, and the taxpayer gets his dividend, and part of it has to reclaim from the tax authorities, as we can see in step 4 here. And then there's a circle of transactions that happen between the original shareholder, the short seller, and the short buyer, through which effectively a double claim is made on the dividend withholding tax, and you can repeat that circle many times. The structure came in different variations. I will leave further links below in the description of the video of what could be done, but that is the background. There were parties that were not shareholders that reclaimed dividend withholding tax from the Danish tax authorities and got quite a lot of money through it. And in that part, we see the gentleman here, Sanjay Shah, who was a major contributor to this robbing of the Danish and German and a number of other European revenue authorities, and his company were Solo Capital. And if we look at what the first court said, the High Court, it said the principal focus of the main fraud allegation is the activity of Mr. Sanjay Shah through his business Solo Capital Partners Limited, together with other entities said to be associated with Solo. There are further significant fraud allegations relating to the activities of individuals initially employed within Solo who came to use the same methods, but then on their own. And if we look at the second paragraph, Skat claims to have been induced by misrepresentations over a 3-year period from August 2012 to 2015 to pay out as tax refunds it was not liable to pay over 1.5 billion pounds, right? That is a lot of money. Allowing for overlap, there were in total 114 defendants. There were 21 separate legal teams from 18 firms representing 74 of them, and the other 40 were either individuals appearing for themselves, some were companies that went bankrupt, etc., etc. But as you can see, a huge and significant case. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. And things did not go well for the Danish authorities in first instance. If we look at the High Court decision, the High Court said the result is that by the application of Dicey rule number 3 in these proceedings, all of Skat's claims fall to be dismissed. So the Danish authorities could not collect money through the UK. And the reason why the UK was involved was because some of these transactions were run through the UK, and that's why they were trying to get these persons being in the UK or having assets in the UK or acting through the UK to get them judged. Things went a lot better before the appeal court, which is the decision of 25 February. And what we see here is that the judge said on Skat's case the granting and payment of the refund applications was induced by fraud, and whilst exploitation of the Danish withholding tax regime may have been the mechanism by which the fraud was committed, it does not follow that the claim involves the enforcement of that regime. The claim clearly has three features which the Court of Appeal in Nimbasago identified as necessary to escape Dicey Rule 3. 1. If in bringing the claim, the claimant is not doing an act which is of a sovereign character, or 2. The claim does not involve the exercise of a sovereign right, and 3. The claim does not seek to vindicate a sovereign act, then the court will both determine and enforce it being the claim. So what is this Dicey rule that we're talking about? The court finally just decided, for the reasons I have set out, the appeal succeeds on ground 1, which was that the Dicey rule should not apply. The claims of SCAT against the alleged fraud defendants are not inadmissible by virtue of Dicey Rule 3. In other words, the 3, they are admissible. And now they will go on to litigate whether these monies need to be paid back to SCAT. But the question is, what is the Dicey Rule? And it is quite an interesting piece of history. As you can see here, we've got the Harvard Law Review, and it is from October 1896, in which they discuss the conflict of laws, which was written by Mr. Dicey and co. And you can see here the Harvard Law Review wrote Dicey's Conflicts of Laws. So this is international law, not only tax law. At last we have an adequate treatise on a branch of the law, the importance of which to an American lawyer is great and growing. Professor Dicey could write, and has written, the best book on the subject. His analysis and arrangement are strikingly novel and commend themselves entirely. And this book from 1896 is in its 15th print when the court looks at this case, and still, as we can see, extremely important in applying UK law. So here is a copy of what the book looks like. I'm not sure if this was the original edition, but that is in any case the book itself. And if we look at what the Dicey rule says, the appeal court says this appeal concerns whether the claims by SCAT are not admissible by reason of Rule 1 of Dicey, Morris and Collins, which provides English courts have no jurisdiction to entertain an action for the enforcement, either directly or indirectly, of a penal, revenue or other public law of a sovereign state. So what it says is that the English court will apply English penal law, revenue law and public law, but not the laws of another foreign state, right? And then the question is, well, why not? And Lord Panic, quite a appropriate name, who was appearing for SCAT, submitted to the court the relevant authorities as to the nature and purpose of Dicey Rule 3, or the yellow highlighted text. And Dicey Rule 3, and this was in State of Norway's application from 1990. Having set out the rule as stated in Dicey, Lord Gough in that case said, it is recognized that the theoretical basis of the rule is a matter of some controversy. The editors expressed the opinion that the best explanation is to be found in the speech of Lord Keith of Avenham in Government of India versus Taylor, in which he said, one explanation of the rule may be thought to be that enforcement of a claim of taxes is but an extension of the sovereign power which imposed the taxes, and that an assertion of sovereign authority by one state within the territory of another, as distinct from a patrimonial claim by a sovereign entity, and a patrimonial claim is an ordinary claim which can be brought by citizens, is contrary to all concepts of independent sovereignties. In other words, one country will not enforce or apply another country's rule, and that was what the Dicey Rule 3 is saying. So the court then goes on and says, let's break down the Dicey Rule, and it breaks it down in two parts. And for me, this video, we know now that the Danish authorities have won in appeal, and that's very good. It's not so much about the appeal, it's about the application of the Dicey rule and then, as it's commonly known outside of the UK, the revenue rule and sovereign act rule, I believe. And let's see what the court says here. It says the critical starting point for the purposes of ground 1, which is that Dicey rule shouldn't apply, is to focus on the scope of Dicey rule 3. What it renders inadmissible, whether under the narrower revenue rule or wider sovereign powers rule, is an action to enforce a foreign revenue, penal or public law. In its narrower form, the revenue rule, what it prohibits is the enforcement of a claim for tax which is due but unpaid. In its wider form, it focuses, which is sovereign powers rule, it focuses on whether the claim is one which involves the exercise or assertion of a sovereign right. In other words, the moment you act as a sovereign in another country, their courts will throw out your claims. If you act just like any other citizens could have acted, then they will entertain your claims like they would for any other citizen, right? And then the court goes on to again claim from the Embasago case, and they say the critical question is whether in bringing a claimant is doing an act which is of a sovereign character or which is done by virtue of sovereign authority, and whether the claim involves the exercise or assertion of a sovereign right. If so, then the court will not determine or enforce the claim, because one country's courts will not apply another country's rules. But the judge says here, he says, in my judgment, this claim against the Scat defendants is not a claim to unpaid tax or a claim to recover the tax at all. It is a claim to recover monies which have been abstracted from Scat's general funds by fraud. And again, remember, if we look here on the right hand side, you can see the ABC transactions. A already got his money back, and BC is said never to have held the share. So there is no taxpayer which received a dividend for which there is a refund to be made. That is the basic argument, right? So because there is no unsatisfied tax claim, back to the highlighted tax, the essential feature of the revenue rule, as Lord Mackay described it in Williams and Humbert, is absent because there is no unsatisfied claim in tax, right? And the court then says, although there is no English authority directly on the point which decides that a claim such as the present one is not a sovereign claim or act of vindication of a sovereign act, that was clearly the view of Dr. Mann in Embasago. Thus, in 1954, in his 1954 article quoted at 42 of the judgment in Embasago, Dr. Mann said, where the foreign state pursues a right by its nature, that by its nature could equally well belong to an individual, the state's access to courts is unrestricted. Thus, a state whose property is in the defendant's possession can recover it by an action of detenue, right? A state which has a contractual claim against the defendant is at liberty to recover the money due to it, right? If the state's ship has been damaged in a collision, an action for damages undoubtedly lies. So as long as the state acts like anyone else does, or anyone else could claim before the court what the state is claiming, then in effect the state can go to court. And then finally, with regard to the revenue rule, the judge says submission by Mr. Zelli QC that by making applications for refunds, the solo etc. Applicants brought themselves within the Danish tax system and became Danish taxpayers is equally misconceived. Their applications were all based on the lie that they had paid tax in the first place, which on Scat's case they had not. That attempt to characterize themselves as taxpayers cannot possibly bind Scat as the victim of their fraud, and the alleged fraud defendants cannot seek to take advantage of their own wrongdoing to bring themselves within Dicey. So you can't just because you lie and you use fraud tax in the process of your lie, afterwards claim, oh, I'm a taxpayer, therefore whatever you do to get your money back, I'm protected under Dicey because I claim to pay taxes, which I never did. So in other words, you gain from your own lie, and that is what the judge here says is not done. So this was the revenue rule, and then there are some points about the sovereign powers rule also. Remember, that was the broader scope, right? And Lord Panic QC submitted that even if there were to be a possibility in this case of the application of a wider sovereign powers rule within Dicey Rule 3, there is in relation to that wider rule a limitation of public policy. The court will not decline to hear a case on the grounds that a claimant is seeking to exercise sovereign powers if there is a public policy reason to do so. So this is what the defense for the Danish Tax Authority said, and the court agrees. It says in his decisions, the judge says, the argument by the alleged fraud defendants that the claim is precluded by the wider sovereign powers rule within Dicey 3 is equally misconceived. In bringing a claim to recover the monies of which it was defrauded, SCAT is not doing an act of sovereign character or enforcing a sovereign right, nor is it seeking to vindicate a sovereign power. Rather, it is making a claim as a victim of fraud. So it doesn't really even address the public policy issue, right? And the judge then also goes on to say the alleged fraud defendant's reliance on the administrative procedures in which SCAT engaged to revoke its decisions to pay refunds is nothing to the point. Those administrative decisions somehow being a precondition of those present claims being brought, and far from supporting the alleged frauds defendant's case that by these proceedings SCAT is exercising sovereign powers, they support SCAT's case that it is seeking to reconcile from the powers that it was induced by fraud to exercise. Not quite sure what the judge says there. Likewise, the first 6 stages of Mr. Jones QC's 7-stage process referred to at 81 above are just part of the background to how the fraud was committed. So the QC said, you know, and we did this and we did this and we did this, and then SCAT went and they did this, and they, you know, and they said that this was a dividend tax that that never was paid, etc., etc. So the judge then said, notwithstanding that at least stages 3 to 5 were induced by fraud, they do not render the 7th stage, the claim made in these proceedings, either a claim for unpaid tax or the exercise of a sovereign power. So again, the judge decides for SCAT, and then he says, referring back to paragraph 60, he says, I agree with Lord Panning that there is nothing in the US-Denmark treaty, we'll get to that in a moment, which entitles SCATs to recover overpayments induced by fraud. Judge Kaplan saying that the DTA was irrelevant because SCAT did not seek to collect tax owed by the offendants and covered by the DTA. We'll deal with that in a moment. Mr. Beale, that was the defendant QC, I believe in the US case, relied upon the fact that SCAT had invoked mutual assistance at international level in order to obtain information from a number of other states, including the IRS. So SCAT did go to the US in the US SCAT case on Cumex, which was against a pension fund, among others, right? I mean, one wouldn't expect pension funds to take part in fraud schemes, but this one did. However, contrary to his submission, that is Mr. Beale's submission, this does not demonstrate that SCAT is exercising sovereign powers in pursuing this claim. It has been open with the alleged fraud defendants as to the information it has obtained and has not sought to use it in these proceedings so as to give itself some special advantage only available to a sovereign body. So what they say is, yes, SCAT has asked for exchange of information. It might have gotten some data. It showed the defendants exactly what it got, and now it's just reclaiming its money back, right? And then finally the court says it is not really necessary to reach any conclusion on SCAT's alternative case that if the wider sovereign powers rule were otherwise applicable, the public exception to that rule should apply here. That's what Lord Panic referred to in paragraph 60. All that is necessary to say is that it seems to me that the view expressed obiter by this court in Iran that there is a public policy exception to the wider sovereign powers rule is correct. I can see much force in Lord Panic's submission that the exception should apply here in case of a major international fraud. So this is what the court has discussed about the revenue rule and the sovereign powers rule, which quite frankly I never thought I would have come across, because one could ask yourself, why not just use Article 27 of the treaty, which is for mutual assistance in the collection of taxes. But in this particular case, there are a couple of points to bear in mind. The first one is that the UK-Danish treaty, for some reason, does not have an Article 27 dealing with mutual assistance. So that's one thing, and I'm not sure that there would have been any other EU rule that would have helped, considering the timing of the case. But there was one in the Danish-US treaty. As you can see here, the Danish-US treaty, Article 7, starts with administrative assistance. The contracting state undertake to lend assistance to each other in the collection of taxes referred to in Article 2. But then we got to remember the point, administrative assistance made by Lord Panic and the US court that we've just seen. I agree with Lord Panic. You see that there is nothing in the US-Denmark DTA which entitles Skat to recover overpayment induced by fraud. Judge Kaplan, as we just read, dealt with the US-Denmark DTA in his memorandum opinion in the Skat litigation in New York, saying that the DTA was irrelevant because Skat claims did not seek to collect tax owed by the defendants and covered by the DTA. And that's what happened here, right? Because this was a fraud case, and yes, the fraud was committed on dividend tax, but still there was no tax to be collected. There was refunds to be collected from fraud, but that doesn't make it a tax, right? And therefore Article 27 did not apply, and you needed some other kind of legal justification for going to the courts in the UK and collecting the money. And that's where the judges said, well, if you do it in a way that every citizen could do it, then you're okay. And since this is not covered by the treaty, it cannot be taxed, because remember, Article 27 also does not only apply for income taxes but for other taxes as well. And since it is not a tax, therefore the Dicey Rule 3 on revenue rules and sovereign powers does not apply. There is one last point that is interesting to make, or question to raise, and that is, if we look at the beginning of the case, the court said, the appeal court said, the position of ED and F MAN is different in the sense that there is no allegation that they were implicated by fraud. Although it is alleged that the misrepresentations were made by them, the misrepresentations are said to have been negligent, right? So they were not quite as informed as the others on what they were doing, and therefore they were only negligent and not fraudulent. And the question would be, if all these excuses which have cut out the Dicey Rule for the other defendants, whether that argument could have applied to ED and F as well. But something went wrong, because the judge says the judge gave permission, that was the High Court judge, to appeal on ground 2 but refused it on ground 1, which before the judge was pursued against all defendants, including EDF and MAN. The application for the permission to appeal on ground 1 was renewed before this court, but not against EDF and MAN. So the High Court thought that you couldn't do appeal on ground 1, and it had some strange argumentation about that, but that's not relevant here. And the judge goes on to say permission to appeal was granted by Males LJ. Ground 1 was not pursued against EDF and MAN for what were described by Mr. Feely QC for Skat as pragmatic reasons, from which it follows that unless Skat is successful on ground 2, EDF and MAN against EDF and MAN, it has to accept that its claim against them is inadmissible because of Dicey 3. Now the judge here indirectly says, I don't know why you guys didn't try ground 1 before us as well. I mean, if you're going to ask for appeal, why don't you just do that here? And then he says, however, because Skat has not pursued ground 1 against EDF and MAN, this court does not need to determine whether the same analysis as one I've adopted in respect of a claim founded on fraudulent misrepresentation would apply to a claim founded on negligent misrepresentation, right? Without assigning the point, since we do not have to, the judge says, it does seem to me that where the claim is against a defendant who obtained a refund by misrepresentation, even if not fraudulent, there is much to be said for the conclusion that in those circumstances the revenue rule should not apply, right? And this must hurt a bit, because what the judge here said is, if you use ground 1 against ED and F MUN, I probably would have given you the right to litigate that further against them as well. Anyway, that was what I wanted to discuss with you this week. I thought it was an interesting case. I thought these were some interesting concepts that we don't come across in taxation that often, because most treaties that we have has an Article 27, but it also underlines how important the existence of an Article 27 is, because if you don't have it, you cannot go to another nation and ask their courts to collect your tax for you. It really highlights the importance of Article 27. Bye for now, and I hope to see you next time.